Hello viewers, as India entering into the Amrit Kal at 100, women's rights are taking the center stage. India's patriarchal society is drifting from glass ceiling to grass breaking effect. So recent Supreme Court split verdict about the liberation of abortion laws has brought Medical Termination of Pregnancy Act into the spotlight. So having said that, I'm your host Madhusudan from National Defense Institute. We'll be discussing about any clouded doubts regarding the abortion laws, especially in India. So coming to video, we will be discussing majorly about what is the story so far that is resurfacing this MTP Act and what is the abortion status in India, and we will be looking about the abortion laws, how the historical underpinnings or the evolution of the abortion laws took place in India, and also we will be looking about the acts and amendments and what are the provisions that has been given in this MTP Act, and also the global trend. We can relatively compare India's abortion laws with respect to other countries, and also an important thing that has been a main crossroad is there is a fetus a living being, and the best way forward what India can take in the future days. So let me explain the story so far which has made this resurface of this MTP Act. Recently, a 27-year-old mother who is already having a two-child has decided to terminate her pregnancy, especially at the 26th week. Why this has raised a contention is, as per the Medical Termination of Pregnancy Amendment Act of 2021, it has raised the gestation period from 20 to 24 weeks. When there is a crossage of this threshold limit of 24 weeks, it requires a medical board's report. And the verdict which was given by the two-lady judge bench has made her to terminate the pregnancy at the instance. But as soon as they got the AIMS report, they have withheld the report, and there came the split verdict, making a pro-choice and a pro-life debate. So that is what making the concern of MTP Amendment Act. Since her decision was after 24 weeks, this has again resurfaced. So what is this pro-choice and pro-life debate? So pro-choice is a one thing where the body autonomy has given an upper hand. That means the woman who is already having a gestation or crossed the gestation of 24 weeks has given a full right to override the MTP Act under the Article 21. So that is what the pro-choice advocates do, but the pro-life advocates are assisting or aiding that even the unborn fetus have a right, and if that fetus is made to die, that is going to set a wrong precedent for the future generation. That is what the pro-life advocates are actually debating. So this debate has still a forward-looking way, but Supreme Court has a much wider ambit where it is focusing more of a pro-choice orders. So keeping that in view, India has tried to liberate some of the abortion laws or the abortion rights, especially to the women in India. So as before I go to the historical underpinnings, I just want to tell basic highlights about what is the condition of the abortion in India. So almost 6.3 million women annually are undergoing a termination of the pregnancy, and almost 13 women die every day because of the unsafe abortion. And this has become a third leading reason for the maternal deaths. And in order to reduce that and realize the full potential of the woman, historically we have taken a liberalization of the abortion rights, especially until 1970. What is the thing is, until 1970s, the abortion was made completely illegal, because any woman who has undergone such a termination of the pregnancy was made to undergo a 3 years imprisonment, which is under Indian Penal Code of 312, and that 3 years imprisonment plus she was undergo or has to pay a fine. So this was a contention mainly to make her right to be arrested. So In 1964, in view of this, to liberalize any abortion laws, a Shantilal committee was set up. This Shantilal committee gave some of the recommendation in order to liberalization of the abortion laws. So based on that committee recording, there was a act that was enacted in 1971, especially treated as the Medical Termination of Pregnancy Act. So this Medical Termination of Pregnancy Act of 1971 was amended in 2021 once again. So this actually shows the wider ambit or the scope for widening the ambit of the women's rights. So keeping that in view, let's compare what is the 1971 provisions and what is the 2021 provisions. So the 1971 provisions majorly tells some of the things as shown in the slide, and also the 2021 provisions. So what I want to tell you is, earlier in 1971 provision that actually told only the married women were allowed to undergo the termination of the pregnancy. But in case of 2021, in order to make the other women to come into the actual ambit, even the unmarried women were allowed to have a termination in the pregnancy. Who are those unmarried women? Means maybe a rape victim or a minority girls or any mentally disabled woman. So this is something widening the aspect of women rights, and especially in case of the gestation period when it is between the 12 to 20 weeks, that was made to undergo authorized, or those pregnant women who are having a gestation of 12 to 20 weeks has to take care of authorized doctors or at least 2 doctors advice before going a termination. But that was reduced to 1 doctor in case of 2021. And when the gestation is between 20 to 24 weeks, it was not at all allowed in the 1971, but that was actually increased with the advice of 2 doctors in case of the 2021. And especially this is where the actual contention that has arisen, because when that is the more than 24 weeks in 1971, they were not at all allowed to undergo the termination, but in the MTP Amendment Act of 2021, they have to go this medical board for substantial fetal abnormality. So the aim, or any board has to tell the fetus is abnormal or that is actually threatening for the mother's life, then only they can undergo the medical termination. So with that in mind, another provision was added. That means, because though we have a lot of legalities or legal grounds to fight such rights, the social stigma attached for the abortion has not at all erased. So keeping that in view, the MTP Act, that is the Medical Termination Pregnancy Amendment Act of 2021, has made that any woman who has undergone the termination of pregnancy, her identity has to be kept confidential, because that is attaching the social stigma where she will be not facing the society in an actual manner. So in order to reduce that, also that confidentiality concept has also brought into the concern. So then, keeping that, we have a global trend where almost all the developing countries and also developed countries have made the inclination towards the liberalization of the abortion rights and also the access for the abortion services. But there are some countries who have recently removed all certain type of legal grounds for the abortion, especially the USA. The constitutional right itself has been withdrawn in the USA in 2022, and even other 3 small countries, El Salvador, Nicaragua and Poland, these countries have completely removed any legal grounds for the abortion of the rights. So with that, we have a very rising question, or the main crossroad question is whether a fetus is a living being or not. Especially when it comes to India, Indian medical healthcare is still at the crossroads. It is unable to decide whether the fetus is a living thing or a non-living thing. So why is that? Because the recent contention that was raised was, as per the AIMS report, the fetus which was there post 24 weeks, that means this lady was decided to eliminate or terminate her pregnancy at 26th week. That means they found that the fetus heartbeat has to be stopped while the termination procedure has to undergo. So in order to reduce that, that will set a wrong precedent for the future generation, because even the unborn child also has a right. So keeping that in view, the Indian Medical Healthcare Board is unable to, or the scenario is unable to decide whether the fetus is a living being or not, and still that has become a unanswered question, and we have to wait and see how the legal scenarios will takes place with respect to the fetus status of living or non-living thing. So the way major forward, I mean the best way forward, where the government is stepping in order to make sure that her rights are not arrested or subsumed. Government has also offered her to actually take care of the child and revisit her decision, so that she undergoes the complete biological process, and so that there is no abnormalities that is formed for the newborn baby. And government has also offered her that the child will be taken care once after her delivery, because the main reason for her to terminate this baby at the 26th week was she was undergoing a post-mortem medication, and that medication had her lot of health issues, and she was unable to take care of the child. This is the actual reason for her to make a termination at 26th week. So, and also the Supreme Court has placed typically a delicate balance where unborn child has also a rights, and also women's autonomy is also very important. So with this delicate balance, Supreme Court is trying to expand the horizon of the women's rights. So what I want to conclude is, the women's rights are more precious, and also the Supreme Court is trying to enhance its ambit with the certain laws and amendments. So this activism will ensure the women, especially in case of the abortion laws. So thank you my viewers. For further videos, kindly do subscribe for the National Defense Institute. Thank you once again.